May it please the Lordship. Lordship, in respect of item number 17, I'm making a mention on behalf of the Legal Aid Council, Mr. M.K. Das. He is indisposed to the Lordship. Can it be some other? Okay, take Lordship.
Mr. M. Das, Learned Counsel appearing for Mr. M. K. Das, Learned Legal Aid Counsel for the appellant has submitted that Mr. M. K. Das is indisposed and has come up for listing of the appeal after a week. After a week? So, MSP Bhuyan and additional senior counsel and additional public prosecutor for the respondent state is present. The prayer is allowed to raise the case after appeal after a week on a basis by the office.
May I please, Lordship, I beg to mention for listing in criminal appeal, Lord. Criminal appeal.
For
orders,
what?
my lord. For orders.
For orders,
Yes, my lord.
for orders.
What order? কি order ছিল?
Criminal appeal.
না কি মানে orders
Normal.
কি বেইলও করে
Yes, my lord. Bail.
Bail.
Yes, my lord.
Okay. You go next to Saibala. Yes.
My lord, I beg to mention, in fact, 3 criminal appeals were filed. Item 15, 16, and the other one is not listed, my lord. These are criminal appeal under the NIA Act for bail, my lord. Now, my lord, the trial court has already granted bail to some of the accused, so we want to approach the trial court, my lord. 15 and 16, I want to withdraw with the liberty to approach the trial court for bail.
15 and 16 want
15 and
to
16.
withdraw.
I want to withdraw with liberty to approach the trial court for bail.
Mr. M. Biswas, who is you are there.
on behalf of Mr.
Learned Counsel. Appealing for the appellant. In these 2 appeals, has submitted that appellants want to withdraw the 2 appeals, in order to approach the learned trial court for relief. Yes, Mr. R.K. Dev Chaudhary, Learned Deputy Solicitor General of India for the respondent, NIA, is present and has no objection to the above prayer. First of, in view of the above submission made by Mr. Biswas, Learned Counsel for the appellants, the appeals are dismissed on withdrawal, with their liberty as prayed for.
My lord, the 3rd bail application in this regard has not been listed. I pray that
You
it may-
mentioned
That is exact. I'm mentioning for at 2 o'clock, my lord. We want to withdraw that also for withdrawal at 2, my lord. No effective order. And replay of that.
May it please the Lordship. I beg to mention item number 13, Lordship.
13.
13, Lordship. Yes. Mr. The master may be passed over for the week, Lordship.
13 is tagged with 14. Okay.
13, 14, huh?
You are Mr.
I'm MZ Shah.
Okay. Mr. MZ Shah, Learned Counsel for the appellant in 13, criminal appeal number so and so, as prayed for an adjournment. Also, Mr. Ayu Chaudhary, Learned Counsel for the appellant in 14, and MS P. Bhuyan and us,
Yes.
Learned Additional Public Prosecutor for the respondent state, are present. And they have no objection to the above prayer made by Mr. Shah. The prayer is allowed. Release the 2 appeals. After
2 weeks, Lordship.
2 weeks. On a date to be fixed by the office.
Please, Your Lordship, I beg to mention for listing of Met Appeal 5/2022, Lordship.
Appeal.
Yes, Lordship, Met Appeal. met
Met
at
appeal.
the, any date this week.
Okay, sure.
Obliged lordship.
May it please your lordship, should I pray for listing of an IA criminal, my lord, for suspension of sentence, my lord?
Okay.
Deeply obliged.
Ready list for admission item number 1.
But this is an appeal, my lord, in conviction under section 4 of the POCSO Act, my lord. And for life. Actually, one thing was not produced at the time of trial, my lord, and he was minor at the time of trial, but that certificate was also not obtained. Subsequently, it was obtained, and I have annexed the same. He is minor. He was minor at the relevant point of time.
Hmm.
So there are certificate I have annexed in the appeal, my lord. My prayer, this same appeal may be, my lord, admitted and my lord, the LCR will call for, and so that at the time of hearing.
POCSO matter notice will go.
Okay.
Yes.
Third, Mr. A. Rashid, learned counsel for the and MS B. Bhuya, learned additional senior counsel and additional public prosecutor for the respondent number 1, State of Assam. Full stop. This criminal appeal under section 374(2) is preferred against a judgment dated 22/01/2024 and an order on sentence dated 25/1/2024 passed by the learned special judge, Gwalpara. In special within bracket P, POCSO case number 17/2020 or 2017. Full stop. By the judgment and order, the accused appellant has been convicted for the offense under section 4 of the Prevention of Children from Sexual Offences Act 2012. And he has been sentenced
7/16.
to undergo imprisonment for life and to pay a fine of rupees 25,000, in default of payment of fine, to undergo simple imprisonment for another 6 months. Full stop. The appeal is admitted for hearing. Let the case records of special P case number 17/2017 be called for, issue notice returnable in 4 weeks as MS Priya, learned senior counsel and additional public prosecutor, has appeared and accepted notice on behalf of the respondent number 1, the issuance of formal notice stands dispensed with. However, learned counsel for the accused appellant shall furnish an extra copy of the memo of appeal.
I will take notice on this note 2, my lord, by register post through the OC, respective OC, my lord.
That is not the procedure now.
Scan copy among the.
For order, item number 2.
Do I have received paper book? My learned friend has not.
I have not received, I have checked it, it is there in the
You are legal aid counsel or amicus?
legal aid council lordship.
MS Hard, MS LDB, learned counsel, legal aid counsel for the SPP, learned senior counsel and additional public prosecutor for the respondent State of Assam. This is 302,
376.
376.
370.
Yes, amicus.
Hard, Mr. N.K. Kolita, learned amicus. Jury for the appellant and MS Endas, learned additional public prosecutor for the respondent State of Assam. IPC offense? IPC.
But I have not gone through it.
Huh?
Today is the first day, my lord.
Session 4.
Hard, Mr. B. Buragohain, learned counsel for the appellant, Epilog Divo. And MS Endas, learned additional public prosecutor for the respondent number 1, State of Assam. Mr. Buragohain has submitted that as the paper book, though the paper book is ready, he is yet to collect the SIM from the office. So he has submitted that he will collect the paper within a week. Both, are you pressing this IA?
Yes.
What is the offense?
T02.
Okay. MS Das, have you filed any objection?
File Lordship.
Okay, heard. Mr. B. Burang, learned counsel for the applicant appellant and MS and Das learned additional public prosecutor for the opposite party number 1, state of Assam. Post of MS Das has paid for and is granted. How much?
2 weeks, Lordship.
Please sign to file objection to the instant interrogatory application filed under section 389 CRPC. List the case after 2 weeks.
Hello.
List the case.
Number 6.
Paper book ready. Foxo Road.
MS and Das learned additional public prosecutor for the respondent state of Assam is in attendance. Hey, it was on 20 years. What is it?
7 to?
You person.
This, sir.
8 years. Has he gone out? The appellants? How many appellants? 3. See the period of detention, incarceration in the cause list.
20 years. Months life.
20 years.
The cause list. Do you have a cause list?
For this,
Yes.
Lordship. in
20 years,
20
11 months, 23 days.
Whether
they are
still inside the jail.
She let me see. Husband.
Let me guess one.
No legal aid counsel.
Given for life. Life means.
Life maybe after remission 20 years. Maybe they have been granted remission. After 14 years, they are otherwise eligible. Whether granted or not granted, that is for our state to decide. But if they are already out, because amicus is also not very interested, perhaps.
I was 7 diploma journal.
Oh, seven. Here it's written Pranab Talukdar and another.
3 perhaps, 3. তিনজন নাকি? দুজন আছে।
Lordship 2.
Okay, 2. Can you get information whether they are still inside the jail? If they are
Take
out,
Lordship.
serving the sentence
My lord.
already, maybe.
Then no use.
Huh?
No use taking up this matter.
Appearing, be here on the previous days.
I'll take instruction.
The learned legal aid counsel for the appellants is found absent today on poster. As the 2 appellants. Are shown to be for 20 years, 11 months, 23 days, comma, as on date, comma. MS Bhuiyan. Learned, Senior Counsel and Additional Public Prosecutor. For the respondent state. Has submitted that instructions should be obtained. As regards the as regards the present status of the appellants.
No, whether, whether they have served out the sentence. or not.
To obtain instruction as to whether the appellants have already served out their sentence. Put a fixed date.
Maybe Nalbari, I don't know whether it's jail option,
This thing, Nalbari.
Nalbari, they are.
So you may obtain the report from Superintendent District Jail Nalbari.
We put it on a fixed date. Please. That is
12/6.
to enable MS Bhuya to obtain and place the instruction.
Whether these two are all the,
No,
all the
no, these
country.
two, I don't, 20 years, 11 months, 23 days already in detention. Find out whether they are in jail or they have already,
Only one.
after
No,
serving
I
the
think so only
sentence.
As regards these two appellants.
No, these two appellants, these two appellants. How many were convicted?
Four.
Sharma and two others. we can say.
Typewriter, you know, there is another issue. Typewriter. Bhupen Talukdar. All the accused persons.
Manav Sharma, Pranab Talukdar, Bhupen Talukdar, Gokul Das, Kalicharan and Jitu Das.
All the accused person.
Submitted charge sheet against accused Manav, Pranab, Bhupen. Yes. Bhupen, accused Kalicharan. Lordship. No, not all. When accused Kalicharan, Jitu Das as doctor and Gokul Das were not sent up by the
No,
IO
no.
as no material. Yes,
As
only-
per the judgment.
yes,
Only 3 phase trial.
yes,
Only 3 phase trial.
yes,
And all of them have been completed.
yes. So
For
Manav,
murder-
Pranab and Bhupen.
Yes, 364, 34, 302, 34, 201, 34.
My lord,
So 3. Find out the
lordship,
appellant.
my lord. Yes, my lord.
We have found,
Yes.
so we have not commented.
I
We have said that a paper book, copy of the paper book be furnished to run the additional purpose. Apart from the legal aid counsel.
Item 10.
My lord, the paper book is ready. I am yet to receive it, my lord.
You are here to collect.
I am yet to receive it.
Hard
my lord.
Mr. T.R. Sharma, learned counsel. You are amicus.
We have filed our objection, the service is complete. my lord.
Learned
As per
amicus. Amicus.
No, legal aid counsel.
Learned legal aid counsel for the appellant. And somebody for 2?
Yes.
Part.
Okay. Miss B. Bhuya, learned senior counsel and additional public prosecutor for the respondent number 1, state of Assam. And Mr.
DJ Bora Lordship.
DJ Boro, learned counsel for the respondent number 2. Full stop.
There is a I, my lord.
Mr. You have received a paper book here?
Here I have, we have received.
The learned counsel for learned amicus curiae for the appellant. And the learned counsel for the respondent number 2 are to collect the paperwork from the office of the office within a period of 1 week.
Yes, my lord.
As the paperwork is ready, come on the office to release the case for hearing in due course.
Yeah.
Lordship, he has preferred on IA.
I have for suspension of the
My lord, in the cause list, my lord, period of detention has been shown as 1 year, 11 months, my lord.
Hmm.
But my lord, at page 9 of the IA, the judgment, it shows he has been in custody since the day of occurrence. That was on 9/5/2017. Thus, it is, my lord, about 7 years.
Okay, you want to prefer the IA?
Yes, my lord.
Press the IA.
I beg to press it.
Okay, list the case.
Calculate person.
Wrongly
Uh,
calculated.
after
Lordship,
2
the
weeks.
submission is the office is wrongly calculated the
calculated.
order of detention.
Office to collect, sorry, the list the case after 2 weeks for consideration of the application under section 389 CRBC.
Yes.
Full stop. As the learned counsel for the parties have submitted that the period of detention of the appellant is, there is some miscalculation as regards the period of detention of the appellant, reflected in the call list, the office to verify the period of detention of the appellant on the basis of the trial court records. Trial court records.
It has been submitted by him, my lord.
Huh?
I have no knowledge.
My lord,
about
it is
it.
there in the.
He has submitted that.
The
Okay,
judgment
that's the
itself, it is
direct
reflected.
amicus curiae.
My lord, legal aid counsel.
Sorry, legal aid counsel. To উপরন্তু তাৰপিছত একো মাজত সোমাই দিব লাগে।
Public.
Item 11.
May I please, your lordship? Lordship, in this IA lordship 506, this is for suspension of sentence lordship. Here I have filed an additional affidavit lordship. One of the appellant lordship, earlier also he has filed an IA before this court lordship. Whether that additional affidavit is there lordship, I have filed in the IA lordship.
Objection, have you, sir?
Yes, you have filed your objection, yes.
Additional affidavit is for what?
Lordship, I want to bring something on record, Lordship, because I have taken one medical ground in respect of one of the applicant, Lordship. He's suffering, Lordship, and he requires surgery. Earlier, I have filed an IA, Lordship, that was disposed of. Those orders I have annexed in this IA, Lordship. One medical report should be called for, Lordship, before
Yeah,
considering
about
this
the
IA,
disposition.
Lordship.
How many applicants here?
Applicants are 3, Lordship. They are all from the same family, Lordship.
Now, which one you want?
Yeah, Hasimuddin, Lordship, in respect of Hasimuddin. This applicant number 1, Lordship. Yes. आपको तो हमने तार condition देखो.
Once we have brought it from the concerned
Yes.
jail authorities, like.
It was a transmission order. See. Mm.
জমা হিসেবে নেবে অফিসার
Medical documents. Yes, I get what I'm saying. Zoom videos.
Oh.
For people who-
নতুন আই ফাইভ পার্সেন্ট রিসেন্ট আছে একটা কপি দেয়া আমার তো আনিব দিয়া নাছিল
Press file.
Which document is indicative of
Lordship.
heart problem?
Lordship, that document they could not collect, Lordship, because only that verbal statement was given. Lordship. Because they are not provided with these documents. Even I have sent one letter as a council. Lordship.
Where are 7 of the initial affidavit?
Think-
Additional affidavit. Do you have the additional affidavit? Why you are not providing?
No, I have served, Lordship. Without serving this, I cannot file, Lordship.
Do you have an extra copy?
কপিটা দিয়া
I will provide, Lordship.
Show it to her.
He's been taking to.
major heart problem for which the surgery could not be done.
And after that
Yeah.
also he was taken
He
again
was
to GMCH, Lordship, for doing some echocardiography or what. But that report we have not received, Lordship. One more thing, Lordship, he is losing weight, Lordship. That is the instruction.
Take instruction from jail.
Heart,
কপিটা দিয়া না
Yes, I will provide you.
heart, Mr. Emma Ahmed, learned counsel for the applicant, appellant, and MSB, learned senior counsel and additional public prosecutor for the respondent state. Full stop. Mr. Ahmed, learned counsel for the applicant, appellant, has submitted that subsequent to the transfer of the
গুৱাহাটী ন
applicant, applicants, appellants, I go to applicant number 1 to the Central Jail, Guwahati.
This month only, date will be coming.
To facilitate his medical treatment,
From
as per the advices of the medical board, comma, the applicant number 1 has undergone certain medical procedures at a GMCH in the subsequent period. For the purpose of undergoing surgery. Full stop. Mr. Ahmed has submitted that on further medical examination by the cardiology department, GMCH, a major heart problem has been detected. And in view of such detection of heart problem, the surgery could not be done. Full stop. Mr. Ahmed has further submitted that the health condition of the applicant number 1 is deteriorating. Full stop. MS Punya. Learned. Bench for the state. Shall obtain a report from the jail superintendent. Jail superintendent, Central Jail, as regards the treatment provided to the applicant number 1 at the ZMCH and the medical opinion as regards his health condition, more particularly, as averred in paragraph 7 of the additional affidavit. You write accordingly.
Lordship.
7, paragraph 7. First, MS Bhuiyan has some listing of the case
7 days,
after- on
7 days,
7 days.
my lord.
Okay. Listing of the case. Choose a date.
11 or 12, your lordship. তুমি কবে সে urgency?
না না
13.
13?
13
Or 12.
14 লর্ডশিপ
Huh?
14
14.
14
14. 6, 2000.
Oh.
Yes.
Lordship, SH for a receipt, to instruction of, this is the instruction.
No, only ALS, ALS.
From the record.
One more time. Yes, here. Now PW2 to Bauschen. PW2 evidence in chief to Bauschen. Here, busy on some. According to documents. 6/2023.
Yes.
That notification dated
Uh-huh.
1/6/2023. First part, your lordships will find that Ms. Nandita Basumatari, advocate as public prosecutor in the district of Srirang, was appointed. And then next paragraph, your lordship will find the government of Assam is pleased to relieve the following advocates from the post of additional public prosecutor. Nandita Basumatari's name is there, but the public prosecutor was not never relieved. He was not there. Therefore, that question of relieving was not there. I have already submitted other day that he submitted his resignation. He was not attending the court. Therefore, question of relieving was not placed before this honorable court even till today.
Oh.
From additional public prosecutor, she was appointed public prosecutor, but she was relieved from additional public prosecutor. But where is that public prosecutor relieved? That is not there.
It means that at that point of time, that post was vacant.
Vacant. That was already vacant. Therefore, question of relieving
So,
was does
madam,
not come.
can you brought that notification from the government? Relieving the earlier PP.
Because he submitted resignation and since then he was not
One
attending.
is already there in the notification, even so, next one.
Oh.
The
Please to appoint.
Corona
public-
Kanto Das
Oh.
with immediate effect. Ekon. Then Daniel Das.
Daniel Das, he was
Daniel Das was appointed on 1st January 2018.
18.
Daniel Das.
Yes, his relief order is not placed.
He was appointed on 1st January 2018. Now,
And to my instruction, Lordship, on 22/2/2022, when charges were framed, he was there, but on that day he was absent. And after subsequent to that, he submitted resignation, and prior to starting of our evidence, Lordship, he was not attending court because of submission of resignation.
Because these are not very foolproof. One gap is there.
Yes.
One gap is there. 2017 এখন বাদ দিল 2018 Kornakan was relieved. Daniel Das was appointed. আৰু এইখনত কি কৈছে ডকুমেন্ট দিলে যে দেখুৱাই যে দিলে তাৰপিছত silence. Daniel Das was relieved tonight. Relieved tonight. Actually decided of Nandita Bosumkari 1/6/2022. Secretary was appointed as public prosecutor on 1/6/2023. She was earlier additional public prosecutor.
Yes.
So she was relieved on the same date, that is 1/6/2023, and she was thereafter appointed as public prosecutor from 1/6/2023.
Yes, Lord.
On the other hand, Daniel Das was appointed as public prosecutor on 1/1/2018. But his relief order, till when he continued as public prosecutor, that is silent. Am I clear?
Yes, Lord.
Daniel Das
Daniel
was
Das
appointed
relief
as
order.
public prosecutor on 1/1/2018. According to Mr. Ahmed, he was there also, his name was there in the list on 22/02/2022 when charges were framed. And the trial court has recorded that PP was not there.
Absent.
He was absent.
Absent.
He was not taking steps
Lordship.
Lordship.
for summoning the witnesses. Then what happened? But he must have been relieved. Otherwise, Nandini Bosumate would have been replacing Daniel Das
Yes.
because of his resignation on the same date or whatever. No vice is there. Vice so and so resigned. Nothing was there.
Your Lordship, order, Lordship. Relief order of Daniel Das, Lordship.
When Daniel Das resigned, or till when he continued. Basically, till when he continued.
Continue.
I think
That is the main,
We don't know whether he resigned or not, but we can say till when he continued.
yes.
And that letter also, his resignation letter,
Yes.
that can also be collected.
Because your thing is another thing, but the procedure required to be followed.
Lordship.
Because what will be the effect, that will be different thing, but at least we have to also see that administration of justice should be
Lordship.
followed with due procedure.
Lordship.
That is what we are
That-
concerned.
Lordship.
I'll bring the.
It may not be the single case.
Lordship.
Then we'll decide your IA. You are there, wait for one more week. Heard MS Mr. A. Ahmed, Learned Counsel for the appellants. Applicants, appellants, and MS and Das Learned Additional Public Prosecutor for the respondent number 1, State of Assam. Full stop. MS Das Learned Additional Public Prosecutor has submitted a communication bearing number so and so. And a number of notifications, including notification number A2 dated 1/1/2018 and notification number so and so dated 1/6/2023. Post by the notification dated 1/1/2018, comma, the Judicial Department, Government of Assam appointed a public prosecutor at Srirang. Post of by the subsequent notification dated 1/6/2023, comma, the Judicial Department, Government of Assam appointed another advocate as public prosecutor for the district of Srirang with immediate effect and ultimate further orders. Post of MS Das, learned traditional public prosecutor, is to obtain instruction as regards the as regards till when to obtain instruction about the date, about the period of continuation of the public prosecutor, comma, appointed on 1/1/2018. Period of continuation. Have you understood? Daniel Das, till when he continued?
Continue and date resignation date.
Whatever, I don't know, we don't know. He has said. So we don't know about resignation, so date of continuation.
Period of continuation.
It must be after 22nd of February 2022. Because on the date of framing charge, he was there. As per Mr. Ame's person.
Okay.
And it appears so.
Yes.
Law is otherwise, one cannot be prosecutor and a judge at the same time. So is that. Next Monday?
On 12th of June. Lordship.
Next Monday?
Monday. 10th. Lordship.
You want 12th of June?
12th.
Okay, 12th of June.
Obliged.
That's 19 to 23.
Sir, may I please finish? My lord, here, this IA has been filed. For my lord. 19 number 19. My lord, item number 19. So, my lord, this
I
IA.
need to be placed before appropriate bench. If some union bench or notification.
Passed by another bench.
It will be the prerogative of that bench, and had that bench or constitution of that bench would have been impossible, we'd have taken up. I think that is the notification, sir.
কালি এটা notification পৰবাৰ এটা ওলাইছে
আছে, কিন্তু
FIR এইটো কভাৰ নকৰিব আমাৰ কাছে
আৰু এটা আছে। আৰু এটা আছে। এইটোৱে হ'ব চাগে। আগৰটা দিছিলো নহয় এই যে আপোনাৰ Okay, regular. Okay. One just is clear, it's clear. Before them. So I can show. We can show. This is also complete for you. We will simply put it hard, Mr.
Yes.
Yes, Sinha. Yes, that is the, I think, procedure.
Lordship, both the judges are available here. It can be constituted.
And Mr. R.K. Devchudri. Learned Deputy Solicitor General of India. Visited by Mr. D. Bharadwaj, Learned Counsel for the opposite party, NIA. Post of the applicant was extended the benefit under section 389, Code of Criminal Procedure 1973 by an order dated 29/9/2022, passed in an interlocutory application, IA within bracket CRL bracket close number 16/2019, full stop, para. The applicant has preferred the instant application seeking alteration stroke modification of a part of the order dated 29/9/2022. Your prayer portion is wrong. Passed in IA criminal number 16/2019. Full stop. Yeah. Attention is drawn to the fact that the two learned judges constituting the division bench, which has passed the order dated 29/9/2022, are presently available. Full stop. In the above fact situation, the registry is to examine the matter by taking into account the notification number number 88 dated 24/7/2023, and thereafter to take necessary steps for listing of the present application before the appropriate steps. They will take necessary steps to be placed before the Honorable Chief Justice.
Obliged.
So because my brother, she got a like he got to control.
Item number 24.
May I please also? The 7 days delay in filing the connected
How
affidavit.
many days?
7 days.
Offense?
Open under section 302. 302.
Yes, Mr. Hart, MSP Bora. Learned counsel for the applicant appellant. And Mr. KK Das. Learned additional public prosecutor for the opposite party number 1, comma. State of Assam, full stop. The instant application is filed under section 5 of the Limitation Act 1963, seeking condonation of delay of 7 days, comma, which has occurred in preferring the accompanying criminal appeal under section 374 2, comma, Code of Criminal Procedure 1973, full stop, para. The accompanying criminal appeal is preferred against the judgment and order dated 10/1/2024, passed by the learned Sessions Judge Sibsagar in Sessions case number 136 within bracket SSS stroke 2016. So, by the judgment and order dated 10/1/2024, comma, the applicant appellant has been convicted. Applicant appellant along with 3 others has been convicted for the offense under section 302 IPC, read with section 34 IPC. And he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000, comma, in default of payment of fine, comma, to undergo simple imprisonment for further 3 months. Full stop. Para. The applicant appellant has provided the explanation for the delay of 7 days, which has occurred in preferring the accompanying appeal, comma, in paragraph 3 and paragraph 4 of the instant application. Full stop. Having gone through the same, comma, we are satisfied that the applicant appellant has been able to show sufficient has been able to provide explanation showing sufficient cause for the period of delay. Post of Mr. Das, learned additional public prosecutor, appearing for the state, has not objected, has submitted that he has no objection if the accompanying appeal is hard on merits. Post of. In any view of the matter, comma, when substantial justice and technicalities are pitted against each other, comma, the substantial justice, the cause of substantial justice is to be preferred. Accordingly, the instant application seeking condonation of delay of 7 days stands allowed. Para, the office to register the connected appeal, and thereafter list the same for admission.
Obliged.
Part heard method for hearing item number 29.
Pass over the matter for a time being.
Okay, we have to hard MS
Only
Mia,
judgments are
then only
placed, my lord.
regarding inconsistencies.
Inconsistencies and the veracity of the, this one, evidence, given by villager, my lord. How far your lordship may believe it? Giriabba, PW1, deceased Mahantappa, accused persons, and also Ranganu Gaura. He further stated that at around 9:30 a.m., Mahantappa was found having sustained injuries on his neck and stated that he covered a towel on the injuries of Mahantappa and shifted him from the place. The towel and chadar are MO 4 and 5. Coming to the evidence of Sangappa PW8 and Chandrasekhar PW9, we find that both of them have deposed that they heard and shouting. When they came near the place of incident, they saw accused 1 and accused 2 assaulting Mahantappa with axe and with sticks. Even though the witnesses were cross-examined at depth, not much evidence was elicited to discredit the testimony of Sangappa PW8 and Chandrasekhar PW9. It is apparent in the evidence of Bhimappa PW10 and Ranganagora that they came to the land of one Rangappa Goli for plowing at about 7 or 7:30 a.m. Then they heard the screaming and rushed to the spot, wherein they noticed the presence of Lakshmabha, who proceeded to the village side to inform the same to the complainant Giriyappa. It is true that there are certain discrepancies in mentioning the time of the incident. Lakshmabha stated that the incident took place at around 11 a.m., whereas Sangappa PW8 and Chandrasekhar PW9 stated that the incident of assault took place at 9:30 a.m. Such discrepancies cannot be a ground to disbelieve the statements of the witnesses if the difference is about 1 hour, as the villages generally suggest the approximate time. Motion. Then identification of the accused at night, my lord. I'll be relying on 2008-11 SCC, 425. There are 9, 10, and 11. Lordship, from para 8, the
Nine.
trial court placed reliance on the evidence laid more particularly by PW8 and directed conviction and imposed sentences as noted so far as the appellant is concerned and directed acquittal of the co-accused. In appeal before the High Court, the main stand taken was that PW8 had undergone eye operation about 2 years prior to the date of occurrence, and in dark night there was no scope for identification. The High Court did not accept the stand and held that identification was possible, particularly when the accused was the grandson of the witness. The appeal was dismissed by the impugned judgment. In support of the appeal, learned counsel for the appellant submitted that all other accused persons have been acquitted except the appellant. The trial court and the High Court should not have accepted the statement of Surya Ram PW8 that he identified the accused from his voice in a dark night, which was not probable. Learned counsel for the state, on the other hand, supported the judgment. The first part relates to the acquittal of the co-accused and its effect on the prosecution version. Learned additional session judge and the High Court have noted that the fact that the only person named as witness was PW8 was the grandson of the present appellant. He did not identify the co-accused person, that is the other assailants. In the instant proceeding, PW8 had mentioned about 5-6 persons, but only identified the appellant as one of the assailant. PW8 disclosed before the court that the deceased went for taking a bath in the canal, and after 10-15 minutes, a jeep came on the bank of the canal. He did not see the other occupants of the jeep and only identified the appellant, who raised a lalkara to teach lesson to the deceased for cultivating the land of his grandfather. The accused persons came with respective weapons and started inflicting injuries on the person of the deceased. PW8 had categorically stated that he did not recognize the other assailants, and though he knew the other assailants, he did not know their names and therefore had not given their names. He had categorically also stated that from the voice of the accused, who raised a lalkara, he recognized the assailant as his grandson. The stand of the appellant that in a dark night recognition would not have been possible from voice, it is clearly untenable. In a dark night, ocular identification may be difficult in some cases, but if a person is acquainted and closely related to another, from the manner of speech, gait, and voice, identification is possible. One more judgment on discrepancy of time. 2012, 13 SCC 213. para 20 and 21. Lordship.
Nineteen, 11. 1 minute.
Very simple. This one.
Yes, next.
SSC 213, para 20 and 21.
There are 20
And 21.
on what point?
Variation of 45 minutes or an hour is giving time constant. Here, someone says 7 o'clock, someone says 7:45,
20 and 21.
20 and 21. The learned counsel appearing for the appellants contended that there are material variations and contradictions in the statement of PW3 and PW6, respectively, with regard to the time of incident as well as date of the deceased. Therefore, neither these witnesses can be relied upon, nor can prosecution be said to have proved this case beyond reasonable doubt. Such a submission can only be noticed to be rejected. PW3 had mentioned that she came to know about the death of her daughter at about 9:30 p.m. However, according to PW6, it was about 8 or 9 o'clock when she was informed of the death of her sister. This would hardly be a contradiction. It is a plausible fact that there could be some variations in the statements of witnesses with respect to a particular incident. Thus, in the facts and circumstances of the present case, a mere variation in time is not a material contradiction. It was the uncle of the deceased PW7 who had been informed by the co-accused, the brother-in-law of the deceased, firstly about the sickness of the deceased and then about her death. Every variation or immaterial contradiction cannot provide advantage to the accused. In the facts and circumstances of the present case, variation of 45 minutes or an hour in giving the time of incident will not be considered fatal. It is a settled principle of law that while appreciating the evidence, the court must examine the evidence in its entirety upon reading the statement of witnesses as a whole. And if the court finds the statement to be truthful and worthy of credence, then every variation or discrepancy, particularly which is immaterial and does not affect the root of the case or the prosecution, would be of no consequences. Reference in this can made to State versus Saravanan. So here in our case, 4 eyewitnesses are there, Your Lordship. So
Time. One is time.
time,
Next is identification.
yes,
Those are possible.
yes. So Lordship, probably the prosecution could prove the case beyond reasonable doubt.
Yes. Same as item number 15,
15,
16.
Withdrawal with liberty to
15,
approach the
16
trial.
to order আছে। Item number 15, 16 to order আছে, same order.
And Biplab Rai.
Item number 15, 16 যিটো আছে, তাতে দুটা আছিলে একেলগে, এইটো single. তিনটা একেলগে মাৰি দিব পাৰে। তিনটা একেলগে মাৰি দিব পাৰে। তিনটা একেলগে মাৰি দিব, এইটো খালি মাৰি দিব। Phone number 29, no? Doctor. This criminal appeal from jail is directed against a judgment an order dated 23/09/2019 passed by the learned Sessions Judge Tinsukia in Sessions case number 17 within bracket CH of 2018 full stop by the judgment and order dated so and so, comma, the accused appellant has been convicted for the offense under section, for the offense of murder under section 302, comma, Indian Penal Code. And he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 50,000, comma, in default of payment of fine, comma, to undergo further imprisonment of 1 year. First, it has been further observed that the District Legal Service Authority in Sukia, it has been further directed to the District Legal Service Authority in Sukia to pay a compensation of rupees 1 lakh to the victim who lost her husband due to the commission of murder by the accused appellant. Full stop. Para. The investigation, the judgment and order, sorry, the Sessions case number so and so arose out of Sangsup Sariali Police Station case number 20/2017. And ZR case number dash dash dash. Full stop. The first information report FIR in connection with Sangsup Sarili Police Station case number 20/2017 was lost by the informant, Srimati Bharati Gogoi, within bracket, PW1, on 14/10/2017 in respect of an incident alleged to have occurred at around 7:45 PM on 13/10/2017. Full stop. On receipt of the FIR, before the officer in charge, Sangsup Sarili Police Station. Full stop. On receipt of the FIR, the officer in charge, Sangsup Sarili Police Station, registered the same as Sangsup Sarili Police Station case number 20/2017 for the offenses under section 302, Indian Penal Code IPC and section 326, IPC, and took up the investigation of the case himself. It on 14/10/2017, registered the same. Post. Para. In the FIR, the informant within bracket PW2 had inter alia stated that at around 7:45 PM on 13/10/2017, a co-villager, Zitian Gugui, that is the accused, raised hue and cry near the gate of the house of the informant. Full stop. At that time, the husband of the informant, Tutu Gugoi, asked the accused not to do so. Full stop. But Tutu Gugoi was inflicted severe injuries by the accused by stabbing him on several parts of his person with a dagger. Full stop. The informant further alleged that the accused had also caused an injury as a stab injury with a dagger on the right hand of her son, Bikudor Gugoi, PW 4. Both the injured persons were thereafter admitted at Sapakwa Hospital for treatment on 13/10/2017 itself. But at around 1 AM, Tutu Gogoi passed away while undergoing treatment. The informant further stated that her son, Bikudor Gogoi, PW4, was undergoing treatment at the hospital at the time of lodging the affair. Para. The investigating officer of the case, PW 13, or visited the place of occurrence in the course of investigation and record it. And prepared a sketch map of the PO PO, place of occurrence, PO, sketch map of the PO by the exhibit 5, EXT 5, full stop. He also recorded statements of a number of witnesses under section 161 CRPC, full stop. He's going on. One dagger was seized by the IO wide seizure list, MR number 8/2017. On 14/10/2017. In presence of witnesses. Full stop. The inquest on the dead body of the deceased was conducted at Sapakwa Civil Hospital on 14/10/2017. By an executive magistrate, witness no হয় নেকি? Witness no হয় যেন পাইছিলো। Not in witness. Not in witness. Executive magistrate. Election officer. For dear. To EXT 2. Full stop. After conducting the inquest, the dead body was sent, or the dead body was forwarded to the no, the postmortem examination of the dead body of the deceased was performed at Sapakwa FRU on 14/10/2017. Full stop. After completion of investigation into Sangsub Sareli Police Station case number so and so, within bracket corresponding GR case number so and so, the IO of the case submitted a charge sheet under section 174(2) CRPC, finding a piracy case. For the offenses of wide charge sheet number 12/2017, on 30/11/2017, finding a variance case. For the offenses under section 302 IPC and section 326 IPC against the accused. So stop. On submission of the charge sheet, comma. The subdivisional judicial magistrate Chabakwa after securing the production of the accused from custody, comma, furnished copies to him under section 207, comma, CRPC on 12/1/2018, full stop. Finding the offense under section 302 IPC exclusively triable by the court of session, comma, the court of the learned subdivisional judicial magistrate Sabakwa committed the case records of GR case number so and so to the court of learned session Judge Tinsukia by an order of commitment dated 12/1/2018 after notifying the learned public prosecutor. Post of para. On receipt of the case records of so and so, pursuant to the order of commitment dated so and so, the learned sessions court registered the same as sessions case number 17 stroke within bracket CH stroke 2018. Full stop. Upon appearance of the accused and after hearing the learned public prosecutor and the learned counsel for the defense, comma, the court of the learned session Judge Tinsukia within bracket the learned trial court framed charges under section 326 IPC and section 302 IPC against the accused. Full stop. When the charges were read over and explained to the accused, comma, the accused abjured his guilt and claimed trial. Full stop. Para. During the course of the trial, comma, the prosecution side examined 13 number of witnesses and exhibited, comma, exhibited 6 number of documents and 1 material exhibit in order to bring home the charges against the accused. Full stop. After closure of the prosecution evidence, comma, the accused was examined under section 303 CRPC. While stating the incriminating circumstances found incriminating circumstances, incriminating materials found against him. Full stop. The plea of the accused denial it is 160/9, no? Was denial, full stop. When the defense accused was asked as to whether he would adduce defense evidence, comma, he answered in the he submitted that he would not adduce defense evidence. Full stop. After hearing the arguments of the learned counsel for the parties and on appreciation of the evidence of materials on record, comma, the learned trial court by the impugned judgment and order as convicted the accused for the offenses, mentioned above, for the offense of murder under section 302 IPC, and he has been sentenced in a manner indicated above. So we have heard Mr. M. Dr. Learned Amicus Curie for the accused and MS B. Bhuya Learned Senior Counsel and Additional Public Prosecutor for the respondent state. Full stop. Mr. Dr. Learned Amicus Curie, appearing for the appellant, has submitted that though there seem to be 4 eyewitnesses, such eyewitness accounts cannot be accepted in toto for the reasons that the entire incident had occurred in the evening hours post of as there was darkness, the identification of the accused appears doubtful. Full stop. Moreover, there were inconsistencies in the testimonies of the prosecution witnesses, in that the prosecution witnesses indicated different times as regards the incident. Full stop. Moreover, full stop. From the prosecution evidence, it has emerged that the so-called eyewitnesses were at a distance from the actual place of incident. Full stop. As there is doubt on the aforesaid aspects, the accused is entitled to the benefit of doubt. Full stop. Para. MS Bhuya, Learned Additional Public Prosecutor, has on the other hand, contended that the prosecution witnesses were from the same locality and village, post of being co-villagers. The eyewitnesses knew the accused since a long time, post of even if from the prosecution evidence, it has further emerged that the accused entered into a verbal altercation with the deceased prior to his murderous assault, and while so altercating, he had shouted, full stop. Thus, it was not only the uh, it was not only the physical identification of the accused, the by which the accused was identified. Full stop. He was also identified by the eyewitnesses from his voice. Full stop. It has been further contended that the accused came to the place of occurrence armed with a dagger, meaning thereby the assault was premeditated. Full stop. Considering the number of considering the nature and number of injuries sustained by the deceased, as emerged from the inquest report within bracket EX3.
61.
2 and the postmortem examination report within bracket EX4, the assault was made in order to commit murder. Matter, there can be no interference with the impugned judgment and order of conviction and sentence passed by the learned trial court. We have reliance reference in order to support such submission, MS has referred to the decisions 1 to 3 in so and so. Full stop. We have given due consideration to the submissions of the learned counsel for the parties and have also perused the materials in evidence to materials including the testimonies of the prosecution witnesses, available in the case records of sessions case number so and so in original. Full stop. We have also gone through, considered the decisions cited by the learned counsel for the parties in support of their submissions. Full stop. As has been mentioned above, the prosecution side examined 13 number of witnesses, including the medical, including the autopsy doctor and IO of the case. Full stop. PW1, Bharati Gogoi, নামটো লিখি দিব এবাৰ। Was the wife of the accused, whereas PW4,
Wife of the big deceased.
oh, wife of the deceased, was the wife of the deceased. And whereas PW4, was the son of the deceased, full stop. PW2, PW3, PW5, PW6, PW7, PW8, PW9, and PW10. Where are co-villagers.
Sorry to interfere. 9 is the son. right?
Oh, okay. 9 to Batio. Are inhabitants of the same village as like the accused and the deceased. That is, Adorho Ahom Gaon. Full stop. Whereas PW 5 and PW9 were sons of the deceased. PW 4 asil na 9. Full stop. Para. PW1, Bharati Gogoi was the informant and the wife of the deceased, full stop, in her testimony, PW1 deposed to the effect that the occurrence took place at about 7 p.m. on 13/10/2017, within bracket 26th day of Ahin. Full stop. At that time, she and her husband were in their house along with their 3 sons. Full stop. And their 11 years old granddaughter from her daughter's side. They are not her. Full stop. At the time, the accused appeared at the entrance of their house and started shouting and abusing at her husband. Full stop. The husband of the informant then came out of the house in order to pacify and to persuade the accused to leave the place. Full stop. But the accused whipped out a dagger and stabbed her husband on his chest at first. Full stop. Thereafter, the accused continued to stab her husband with a dagger on different parts of his person at neck, head, etc. Full stop. Seeing such stabbing, PW2 once stated that seeing such stabbing, she shouted for help. And her son, PW4 then came out and ran to the place of occurrence. Full stop. When her son, PW4 tried to restrain the accused, he was also attacked by the accused with a dagger. Full stop. As a result, PW4 also sustained serious cut injury on his right hand as the dagger went through his right hand. Full stop. Thereafter, the accused ran away from the place of occurrence. Full stop. PW2 once testified that she had seen the entire incident taking place in front of her. Full stop. Then, Tutu Gogoi was brought inside the house. Full stop. But from the brought inside the house, but the accused and his elder brother, Biren Gogoi, started to pelt stones at the house of the informant. So because of such pelting, PW1 stated that because of such pelting of stones, they were unable to come out of the house. However, PW4 somehow managed to go out of the house through the back door and informed about the incident to his brother-in-law, Sanu Bhorolua. Full stop. Sanu Bhorolua then taking PW4 along with him, went to the VDP personnel and thereafter, the police, the VDP personnel along with police came to her house. Full stop. A vehicle was arranged thereafter in order to take Tutu Gogoi to hospital at Sapakwa. Full stop. When Tutu Gogoi was taken to Sapakwa, the doctors there declared Tutu Gogoi to be dead. Full stop. The wound sustained by PW4 was dressed by the doctor. PW1 deposed that it was on the following day, that is on 14/10/2017, the FIR within bracket EXT1 was lodged. PW1 further stated that an executive magistrate conducted inquest on the dead body of Tutu Gogoi. And in the inquest report, EXT2 bracket, so prepared, she gave her signature as EXT21. Full stop. PW1 further identified a dagger within bracket met EXT1 and stated that it was by that dagger, the accused had stabbed her husband on her chest. Full stop. Subpara. During cross-examination, PW1 stated that the entrance gate at her compound where the occurrence took place, was situated at a distance of about 50 meters from her house. Full stop. At that time, the place of occurrence was lit by street light. Full stop. PW1 further stated that there was no separate light at the entrance gate. Full stop. Both sides of the passage to her house from the main road had tall grasses, and there was a bamboo grove on the right side of the place of occurrence, and a ditch on the left side of the place of occurrence. Cello ditch. PW1 further stated that on the day of occurrence, there was no fog, though it was winter. And there was darkness at that time. PW1 further stated that the house of PW2, Horendra Lahon, was situated by the side of their house. And there was an empty space between the house of PW2 and the accused. And in that place, one Kumud Gogoi used to keep some logs. Post op. PW1 further clarified that her husband Tutu Gogoi was not involved in any manner with PW2 in connection with the logs which PW2 Farendo Lahon and the accused. Full stop. PW1 denied suggestions that she did not state before the police that in front of her eyes, the accused whipped out a dagger and stabbed her husband on his chest, semicolon, that she had seen the occurrence taking place in front of her eyes. Full stop. PW1 also stated that on the date of occurrence, her husband had consumed liquor, but denied suggestion that she had testified in a false manner. Para. The testimonies of other witnesses, other four testimonies are of the other three prosecution witnesses. That's PW 4, PW 6, and PW 9. That's are the three prosecution witnesses. That's so and so. Also narrated about the incident. PW4, Bikudhar Gogoi. Deposed to the effect that the occurrence took place at about 6-00/7-00 PM on 13/10/2017. He testified that at that point of time, he was studying inside the house. While he was studying inside the house, heard the accused shouting at someone in front of their house. As he was preparing for his exam, his father, Tutu Gugoi, told him not to make noises. Immediately thereafter, he heard his father, Tutu Gugoi, shouting and telling that he was being attacked. Then his mother, PW1, went out of the house, hearing the voice of her husband, Tutu Gugoi. Then, his mother, PW2's mother, PW1, shouted, asked him to come out of the house. In response, PW2 came out of his house and saw that the accused and his father and accused saw the accused lying saw the accused on the ground with his father over him. And the accused was stabbing his father from below with a dagger. Full stop. When he tried to raise recover rescue his father, the accused also attacked him with a dagger. And the dagger pierced through his right hand. Thereafter, the accused ran away along with his wife, who was also with him at that point of time. As his father was shouting in pain, brought him inside the house. After some time, the accused and his brother started pelting stones at their house. PW2 then went out of the house through the back door to reach the house of his brother-in-law, Sanu Horolua. Who, with PW2, went to inform the PDP thereafter. With the help of, they returned home with the PDP personnel. Thereafter, one vehicle was arranged and his father was taken to the hospital at Chapakwa. But before reaching the hospital, his father breathed his last. PW4 had stated that he also took treatment. He took treatment for his injury at Chapakwa Hospital. PW2 also stated that his father sustained multiple stab wounds on his chest, stomach, and head. Subpara. When PW2 was cross-examined, he stated that the passage used to remain dark at night. As regards light, presence of light, PW2 stated that there was no light at the place of occurrence on the date of the incident. When he was asked, PW2 stated that he did not remember whether he had stated before the police that he saw that the accused was lying on the ground and his father was over his body, and from below, the accused was stabbing his father with a dagger. Semicolon, and that the wife of the accused had hit him with a bamboo. He denied suggestions that they had attacked the accused and beat him at the time of occurrence. Semicolon, and that the accused did not cause the piercing injury in his right hand. PW 6. PW 6 deposed that he knew the informant, the deceased and their son, PW 4. As regards the incident, PW 6. Deposed that the incident occurred at around 7:30 p.m. on 13/10/2017. Pusta. At that time, he was in his house. Pusta. Hearing the sound of Pusta, he stated that he had heard sound of a quarrel that was taking place near the house of the informant. Pusta. Going there, he saw the deceased and the accused wrestling on the ground. Full stop. PW6 stated that both of them were bloodstained. Bloodstained. Full stop. He saw the presence of the informant, PW1 and her son, PW4, as they had come to the place of occurrence. Full stop. PW6 also stated that at that point of time, the accused attacked PW4 with a knife, for which he sustained an injury in one of his hands. Full stop. Thereafter, PW1 and PW4 took away the disease into his house, and full stop, the accused ran away from the place of occurrence. Full stop. PW6 testified that thereafter, he saw the accused throwing stones at the house of the deceased. Throwing stones and firing arrows. Firing? No, sorry. Shooting. Shooting arrows towards shooting arrows from a bow towards the house of the deceased. Full stop. He further stated that an ambulance was called and the deceased and PW4 were taken to hospital full stop, when police personnel came to the place of occurrence, comma, on the following day, one dagger was recovered from the jungle near the place of occurrence, a bloodstained dagger. And the same was seized by the CGLS, EXT3, wherein he gave his signature as EXT31. Full stop. PW6 also identified the said seized dagger when it was produced before him as MET EXT1. Full stop. Subpara. During cross-examination, PW6 stated that PW4 sustained the injury in his right hand. Full stop. He further deposed that MET EXT1 shown to him, did not contain, shown to him before the court, did not contain any bloodstain. Full stop. As regards the time of occurrence, PW6 stated that the incident happened when during darkness. Full stop. He, however, clarified that the faces of the people could not be, he further stated that faces of the people, faces of persons could not be recognized without the use of a torchlight. Full stop. He denied other suggestions put to him by the defense. Full stop. Fair enough. PW9 was, PW9 was
Eyewitness.
eyewitness. PW9 was another son of the deceased. And he knew the accused as well. Full stop. Narrating about the incident, PW9 stated that occurred at about 6:30-7 p.m. on 13/10/2017. Full stop. At that time, he was doing his studies. Full stop. When he was doing his studies. At that time, at that time, the accused, by standing in front of their house, standing on the road in front of their house, was shouting as he was doing his studies for examination, his father went out of the house to ask the accused to go from the place and not to make any noise. Full stop. PW9 stated that from their house, he saw that the accused was having quarrel with his father, had a quarrel with his father, and dealing several blows on different parts on different dealing several blows at different parts of his father's body with a dagger. He saw his father collapsing on the ground, and his mother, PW1, and his brother, PW4, going out of the house to bring his father back to the house. Full stop. PW9 testified to the fact that when his brother, PW4, tried to interfere in between his father and the accused, he was assaulted by the accused with the dagger. Full stop. And a dagger which pierced through the which pierced through the right hand, through his right hand. Full stop. Thereafter, the accused and his brother started to pelt stones at their house. Full stop. PW9 also stated that he went out of the house to the back door. He sneaked out of the house through the back door and went to the house of his brother-in-law. Thereafter, his brother-in-law and his elder brother, PW4, went to inform the VDP personnel. He, with his sister, returned home. The PW9 further stated that his father was taken to hospital thereafter. In a vehicle. And in the hospital, his father was declared dead. Full stop. As regards the place of occurrence, PW9 stated that there were bamboo groups on both sides of the places connecting their house and the road. Full stop. As regards the time, PW9 stated that the entire area was dark and without torchlight, it was difficult to identify persons. Full stop. PW9 further stated that at the relevant time of occurrence, it was cold and foggy. Full stop. Para. From the testimonies of PW1, PW4, PW6, and PW9, it is established that it has been established that the incident had occurred on 13/10/2017, that is, 26th day of Ahin. So the place of occurrence was near the gate of the house of the deceased, full stop. There was a passage from the gate to the house of the deceased, whose of the family members of the deceased, comma, that is his son, his wife, within bracket PW1, comma, and his 2 sons, within bracket PW6 and PW4 and PW9, were present at the house at the relevant point of time. Full stop. None of these prosecution witnesses has PW1, PW4, PW6, and PW9 were was confronted by the accused as regards the their depositions, that the accused, by appearing at the entrance of the house of the deceased, comma, started shouting at the deceased. The defense did not even put any suggestion to these prosecution witnesses that at that point of time, comma, the accused was not armed with a dagger. Full stop. The defense also did not confront these prosecution witnesses, PW so and so, with any kind of suggestion that after leaving the place of occurrence, comma, The accused and his brother pelted stones at the house of the deceased. Like what? Full stop. In the backdrop of such evidence stroke materials on record, the testimonies of the other prosecution witnesses can be evaluated. First off, PW2 like the previous, like other witnesses, other prosecution, PW2 also stated that the incident occurred prior to 4 days prior to the advent of Kartik month, advent of the month of Kartik. Full stop. PW2 deposed to the effect that at around 5-00/6-00 PM, he was going to the matrimonial house of his daughter and on the way, he met the accused who was holding a dagger in his hands. Full stop. PW2, when shown Matt EXT1 in the court, testified the dagger as the one which he found in the hands of the accused. Full stop. PW2 went on to depose that when he was in the matrimonial house of his daughter, he was informed that there was a quarrel going on in the house of Tutu Gogoi. Full stop. Then he came out and went to the place of occurrence and saw pelting of stones towards the house of Tutu Gogoi. Full stop. He stated to have heard that it was the accused and his brother, Biren Gogoi, who were throwing stones at the house of Tutu Gogoi. Full stop. He stated that PW2 stated that he heard that the accused had stabbed the deceased with Tutu Gogoi with a dagger and also stabbed the son of Tutu Gogoi, Bipudar Gogoi PW4, who also sustained an injury. Full stop. PW2 further stated that when at about 10 AM on the day following the date of the incident, comma, police personnel came and searched for the dagger. Police person came and uh, uh, mm, police person came. Full stop. A dagger was recovered from near the place of occurrence inside the grasses. And full stop. When PW2 was shown the dagger in the court, comma, he has met EXT1. Oh, sorry. He stated that in the seizure list,
Exhibit 3.
comma, EXT3, whereby met EXT1 was recovered, comma, he gave his thumb impression therein. Full stop. Software. No, not like a software. In cross-examination, comma, PW2 stated that the place where from the dagger was recovered was accessible and the dagger of the kind which was recovered was readily available. Full stop. PW2 also stated that he had seen the injury on the hands of the deceased. Full stop. Para. PW3 was a post-occurrence witness. Full stop. He stated that the incident took place at about 6:30 p.m. when he was in his house. Full stop. He was informed that the accused had committed the murder of Tutu Gugoi. On receipt of the information, comma, he immediately went to the house of Tutu Gugoi. Full stop. Going there, comma, he found Tutu Gugoi lying on the floor of his house. Full stop. PW3 stated that he was told it was the accused who had stabbed Tutu Gugoi. PW3 stated that he saw stab wounds on his chest, comma, stomach and neck of Tutu Gugoi and an injury in the hand of PW4. As the dagger went through his hand. Full stop. Police personnel came to the place of occurrence in his presence. And recovered a dagger from near the place of occurrence. Full stop. He identified Matt EXT1 as the dagger which was recovered by police from the place of occurrence. Full stop. When PW3 was cross-examined, comma, he admitted that he did not state before police that he was told he had noticed Tutu Gogoi lying on the floor of his house and was told that it was the accused who had stabbed him. Post up. Koila. PW5. Stated that the incident took place on 26th day of Ahin. You got a question. So, PW5 deposed to the effect that during the daytime, on the date of the incident, he met the accused who stopped at that time, the accused showed him a dagger and told him that he was going to do something with it. Stop. At around 7:30 p.m. on the relevant day, he was passing by the house of Tutu Gogoi. When he was passing, he heard shouting of Tutu Gogoi and saying that the accused had stabbed him. Full stop. Then PW5 entered into the house of Tutu Gogoi and saw Tutu Gogoi lying on the floor of the house, staining with blood and having stab injuries on his neck, chest, back, etc. Full stop. PW5 further stated that when he was in the house of Tutu Gogoi, police personnel arrived and the Tutu Gogoi and arrived and Tutu Gogoi and Bikudhar Gogoi, PW4, who also received an injury in his right hand, were taken to hospital. Full stop. But Tutu Gogoi, before reaching the hospital, succumbed to his injuries. Cross-examination. In his cross-examination, PW5 stated that the day when the incident had occurred, was was cold and foggy. Full stop. As regards the place of incident, PW5 stated that there was no electric light on the road when he was traveling by the road at the relevant time of occurrence. Full stop. 7. PW7 stated that the occurrence took place in the evening hours of the 26th day of Ahin, my brother Jiten Gogoi, no, 1 second. Oh, she was daughter. PW7 was the daughter of the deceased.
One is the daughter, yes.
PW7 was the daughter of the deceased.
She stays at some distance, man.
PW7 stated that when she was informed by her brother, Zibon Gogoi, that her father was stabbed by the accused, she went to her paternal house. To stop going there, she saw her father. She saw her father sustaining cut injuries on his forehead and on several parts of his body. So she saw her brother, PW4, sustaining an injury on his right, piercing injury on his right hand. Stop. She was told by PW4 that the injury was caused by the accused. Stop. She stated about shifting of her father and her brother, PW4, to the hospital by the police personnel. Stop. PW4 was confronted with a part of her previous statement recorded under section 161 CRPC by the defense. And PW7 denied the suggestion. Denied to have denied that, affirmed that she made such statement before police. Here give us any rule that on Google. PW8 stated that the occurrence took place at about 6:30-7 p.m. on the 26th day of Ahin. On hearing alarm raised by PW1, he went to the house of Tutu Gogoi. Going there, he saw Tutu Gogoi lying in an injured condition with stab injuries on his head, chest, etc. He was told by, he had heard that the accused had caused the injuries to the deceased and PW4. As he was requested by PW1 to inform VDP personnel and the police, the VDP personnel was accordingly informed by him. The VDP personnel had, in turn, informed the police over phone. It was after some time, the police personnel came to the place of occurrence. He stated that he, as a witness, subscribed his signature as EXT22 in the inquest report, EXT2. where during cross-examination, PW it affirmed that he stated in the same manner before the police, as he had stated before the court in evidence in chief. Like many of the prosecution witnesses, PW10 also stated that the occurrence took place on the 26th day of Ahin. Full stop. The testimony of PW10 is not of much relevance as his evidence is in the nature of hearsay. Full stop. 11 কিবা আছে নেকি?
11 to common. Date of occurrence, time of occurrence.
VDP নেকি? না, PW11 was the secretary of the local VDP. Full stop. PW11 corroborated the version of PW4 that after the occurrence, PW4 and his brother-in-law, Chanu Bhorolua, came to his house to inform that the accused had assaulted Tutu Gogoi. Full stop. As PW11 was requested by PW4 and his brother-in-law Chanu Bhorolua, he deposed that he had accordingly informed the police of her phone. Full stop. When after 1 hour, police personnel came to the village, he led them to the house of PW1. Full stop. Going there, he saw Tutu Gogoi was lying on the ground with a punctured wound on the right side on his chest and wounds and on his forehead. Full stop. According to him, Tutu Gogoi was alive at that time. Full stop. Since Tutu Gogoi was alive at this time, he was taken to hospital by a vehicle. Full stop. He later on was told that Tutu Gogoi died in the hospital. Full stop. In the cross-examination, PW11 deposed about the place of occurrence. Full stop. He stated that the entrance to the house of PW1 had bamboo groups on both sides. And the area was often dark. And without a torchlight, things were not visible. Full stop. এখানে লাগে না। দেরি হবে নাকি আপনার? আপনার দেরি হবে। On a একটু কন্ট্রোল করে দিন একটু রে। লাষ্টত begin.
দিলে হ'ল সেইটো। তেওঁ হেৰিয়াৰ পৰা উঠাই দিব এইটো।
এইটো আমি নকওঁ, এইটো মানে এইটো এনালাইচিস কৰি পেলাই evaluation of the prosecution witnesses, prosecution evidence, comma, it has emerged that the testimony of the prosecution witnesses PW1, PW4, PW6 and PW9 are amply corroborated by the other prosecution witnesses. In that the incident had occurred in the evening hours of 13/10/2017, that is 26th day of Ahin. So stop. All the prosecution witnesses had testified that to the fact that Tutu Gogoi sustained injuries on his head, chest, etc. Full stop. The prosecution witnesses dash PW এগাৰ কোনে কোনে পালে বা? PW2 comma PW3 PW six had all deposed that they were present when the alleged weapon of assault, comma, a dagger, was recovered by police personnel from near the place of occurrence and was seized by exhibit. Seized by the exhibit 3, comma, seizure list. 6. PW2, comma, PW3 and PW6 were witnesses to the seizure list, comma, EXT3. To stop. When these three witnesses were shown the dagger comma, seized by Caesar's EXT3 before the court. At the time their depositions were recorded, comma, they identified the dagger as the one which was recovered by police from near the place of occurrence by Caesar's EXT3. Poster. The only suggestion put to this prosecution witnesses by the defense was to the effect that the kind of dagger which was seized by the Caesar's EXT3 was a dagger which was otherwise commonly available the from the from a comprehensive after going through the testimonies of the prosecution witnesses, above prosecution witnesses, more particularly the cross-examination of their cross-examination command, it is found that the prosecution witnesses, the defense was not able to elicit anything to discredit the credence on any material points. Poster. Para. In the above poster, the prosecution has been able to lead cogent evidence to the fact that on the date of during the incident, the accused had assaulted the deceased by a dagger, and in the process, according to the prosecution witnesses who had seen the occurrence, the accused had stabbed the deceased on several occasions. Para. The autopsy doctor who had performed the PW12 was the deputy superintendent was serving as deputy superintendent Sapakwa FRU on 14/10/2017. It was on 14/10/2017, PW12 performed postmortem examination on the dead body of Tutu Gogoi. After examination, on the examination of the dead body of Tutu Gogoi, he in the post-mortem examination report, comma, exhibited as PW EXT 4, comma, recorded the following. Page 32. Two. Huh? Dark dias. PW 12, in his opinion, had opined that the death was caused এইটো নহয় 32 দিব নালাগে ইয়াতহে বেছি ইয়াতে আছে বেছি এইবোৰ লিখা আছে চব চাপ নাই so lungs exercise বহুত আছে বহুতে আছে material lung intestine contain muscle খুব নালাগে হ্যাঁ he opined that the death occurred due to heavy 70 বা 73 huh? Death occurred মাঝে মাঝে যিখিনি আছে স্টার কৰি দিব যিখিনি নালাগে due to heavy blood loss from severed deep vessels and direct injury of gray matter within bracket penetrating temporal bone. Mr. Dotto will have single benches also. Post it tomorrow. As part of no way out. Otherwise, you could. Yes, madam. Then single bench. Kali part of State Council, anything regarding how to resolve the issue? Monjo Ghosh.
I have informed to Mr. Nat, Lordship.
Any idea?
No, Lordship, we have not received any instruction, Lordship. They have to apprise the court, Lordship.
Senior
regarding the
government,
final
Mr.
order.
Dinat was supposed to.
Yes, Lordship.
Learned counsel for the petitioner. Now petitioner is not represented. No, learned counsel for the petitioner is found absent today on call. Mr. Borua, you were there. Okay. You have any role?
We have to, because we have only action paper is sent by us only in 2022 itself regarding misappropriation amount 9,61,330. That clarification required. That we have returned back in 2022. However, it is 22. I am also not up to date information regarding this.
No. Basically, he was found convicted for two offenses.
Yes.
Involving mens rea, forgery, cheating, etc.
I think misappropriation also.
So he was convicted, then he's he went.
Yes. And his
He was
pension
in jail.
held up, Lordship.
Huh?
Lordship, his pension was held up.
He had undergone his
Yes.
sentence.
Yes.
because his appeal was dismissed. Then he was departmental proceeded with. Then the departmental procedure also found him guilty of the charge. Thereafter, he died, but he was receiving provisional pension. Despite conviction,
He is getting.
despite guilty in the DP, in the criminal proceeding, then he expired. And he went on receiving money, provisional pension till that for a sufficient period of time. But what kind of final decision has been taken as regards his service by the government? That is the question.
Our question is.
We
this,
cannot take the decision on behalf of the government.
Our question was there, we returned misappropriation, not clarified.
We cannot take a decision on that. That is the difficulty we are facing.
It's our information.
Okay.
Maybe
Wow.
1 week's time, otherwise the endorsement we have, they have received. But we are requested by the department to take a week's time so that they can furnish us the.
Okay, Mr.
I am for-
NK Sharma,
For response number 3 and 4.
counsel representing Mr. H.K. Das, Learned Standing Counsel GHE for the respondent number 3, 4, and 6, and Mr. C. Bolwal, Learned Standing Counsel Accountant General ANE for the respondent number 5 are present. Miss
You Sharma. ma'am.
EU Sharma, Learned Counsel, appearing for Mr. D. Nath, Learned Senior Government Advocate for the respondent number 1 and 2, has placed a communication bearing number so and so dated 1/6/2024 of the Judicial Department, Government of Assam, and has submitted that the case be listed after 1 week as the department. As the matter is under consideration of the department and the required information will be placed after a week. Post op, as prayed for by MS Sharma, Learned Counsel. A list the case after a week on a date to be fixed by the office. The communication bearing number so and so, dated so and so, is kept with the case record.
Highly obliged.
Yes, Mr. Gugoi.
Lordship, in this matter, we are seeking an adjournment, your lordship.
Okay. Will not be able to fix, I am not sure.
Let
About my
your lordship,
roster.
when it comes, we'll mention it and then we'll list it.
Just put it after 2 weeks, you make a mention. Mr. A.R. Gugoi, Learned Counsel for the petitioner, and Mr. N.K. Sharma, Learned Counsel representing Mr. H.K. Das, Learned Standing Counsel GHE are present. On the prayer of Mr. Gugoi, Learned Counsel for the petitioner, list the case after 2 weeks, on a date to be fixed by the office. Then when it will be listed after 2 weeks.